uh, enti- entitled SB and CB versus Sedgwick County Area Educational Services. We have Mr. Chris Dove here for the appellant, and I believe Mr. Andrew Folston for the appellee. Mr. Dove, we will begin with you, and let me first ask, do you wish to reserve any time for rebuttal?
Your Honor, 5 minutes, please.
That is granted, and you may proceed.
Thank you, Your Honor. As Your Honor said, I represent SB and CB on behalf of JB, and we filed suit in the trial court against the appellee, which is an interlocal cooperative that no longer exists. The purpose of this interlocal was to provide teachers and paraprofessionals into school districts in the Wichita area who were special education teachers and education providers. And these people were employees of the interlocal. This case involves an assault by one of their employees, Jessica Alves, against my client, JB. And in particular, our claim against the interlocal was a negligent supervision case. And the trial court granted summary judgment on behalf of the interlocal, ruling that we needed an expert to come in and provide expert testimony on the duty and the breach of duty in the interlocal's negligent supervision. So I'm going to start with some law, some Kansas law. And in particular, Kansas, the law is that you don't generally need an expert to provide testimony in the case. And I'd like to point the court to the Kansas Supreme Court ruling in 1997, Moore versus Associated Material and Supply Co. And the court in that case said that holdings of an expert testimony requirement outside the area of professional liability, where breach of standard of care must be proven, are not easily found. Meaning that when you wander outside of the area of a professional liability case, it is very difficult to find a case in which a Kansas court has ruled that an expert is needed. And that's evidenced here in this case because, to my knowledge, there's not another Kansas case in which a court has held that you need to have an expert to opine in a negligent supervision case about either duty or breach. And I think that the issue in this case is that the court did make that ruling. And I think the briefing demonstrates that that would be a new and unusual ruling to have in the state of Kansas. And the reason for that is, in Kansas, what experts are needed for is when there's technical issues or what the court is called alien issues that may be outside of the purview of a lay juror. And in the Junkie case, Juhnke case, the Kansas Court of Appeals explained that the purpose of expert testimony is to benefit the trier of fact when when the facts are somewhat alien in terminology and the technological complexity would preclude an ordinary trier of fact from rendering an intelligent judgment. So in other words, sometimes you need an expert to come in to explain to the jury within this realm of professional liability, doctors, engineers, there's a certain standard of care within that world. Or we're dealing with something technical like, say, software or a medical device, and the jurors need the benefit of an expert to come in and explain that technology so that the jurors can then understand what the issues are and render a verdict. And in this case, there are no questions of professional liability. This is not a medical malpractice case. This is not negligence in a nursing home. This is not an engineering case or a construction case. And there are not technical issues that a jury would not understand. There's no technologies at issue here. And I think you can see
Mr. Dove,
yeah.
sorry to interrupt you. So is it your contention then that the conduct of these teachers or the supervision of these teachers does not fall within the realm of a professional area requiring expertise? Is that the argument?
Yes, Your Honor, that would be my argument that in this case, a teacher and a teacher's conduct. So to distinguish, we're not talking about a teacher providing, we're not looking at the issue of a teacher, whether a teacher is adequately providing, say, special education services. Instead, what we're looking at is a teacher's conduct around students. And within that context, I do not believe that that's an issue of professional liability or professional conduct that a juror needs the benefit of an expert to explain.
Thank you.
And on this issue also, I would point the court towards the trial court's, part of the trial court's opinion. And I think that the trial court's opinion, when looked at also, it demonstrates that there are not technical issues or professional ability issues. And in particular, I'm looking at page 22 of the opinion. This would be record 3 at page 22, where the court, towards the end of the opinion, is saying, so the issues then become: 1, did defendants really have notice of Alves's purported temper? 2, if so, did the defendants really have notice that Alves's temper could possibly be directed at students? If so, 3, why in that case was the school principal not enough? 4, if the principal was not enough, what supervision was the defendant required to meet the standard of care? And I would argue that nothing in that explanation evokes a need for a technical explanation or a professional liability issue. But I would also say that even if we're looking at a case where there is, say, technical issues, or it's a professional liability case, an engineering case, a medical malpractice case, that Kansas law still recognizes that there's certain conduct by a defendant that is so obviously lacking in reasonable care that an expert would not be needed. And I again refer back to the Junkie case, Juhmke, that involved a nursing home. And in that case, there was one patient in the nursing home who physically assaulted another patient at the nursing home. And the issue there was expert testimony needed to explain to jurors whether the nursing home upheld a standard of care in supervising its residents. And the court held there that the treatment and care of this patient was so obviously lacking in reasonable care and had such serious consequences that the lack of reasonable care would be apparent to and within the common knowledge and experience. So in other words, an expert would not be needed because the defendant's conduct was so obviously lacking in reasonable care. Because that is, in a negligent supervision case, that is obviously the standard, is did the defendant exercise reasonable care in their supervision? And to point to findings of fact from the trial court, on the one hand, the trial court found in its opinion at page 5 that, quote, the defendants weren't doing the day-to-day supervision of Alves, end quote. So the Interlocal was not supervising Alves. The Interlocal was not supervising its employees. It was putting Alves in the school building, and it was just hoping that someone else would supervise Alves. It was not doing its job as an employer. The trial court also found that it was uncontroverted that during Alves's interview, that she admitted she had issues handling conflict. And also the trial court found, it was uncontroverted, that several paraprofessionals that worked in her classroom had noticed various aspects of Alva's temper, either her kind of blowing her top, her yelling at people, her threatening people. And these are all demonstrations, and as the trial court said at page 21 of its opinion, and as I said in facts, plaintiff's facts 9, 10, and 11, and those are the facts we're talking about here, meet those requirements for putting the trial court says plaintiff, the trial court meant the defendant on notice. So even the trial court is recognizing that the defendant had notice of Alva's admitting to having issues with temper, Alva's having an explosive temper, and then also that the interlocal was not supervising Alva's. And these are all demonstrations of an obvious lack of reasonable care. When you have an employee, an adult, and you're putting that employee in charge of children, school-aged children, this is an obvious lack of reasonable care, in which case an expert would not be needed. So I think that the choice in front of the court is to reverse the trial court because an expert is not needed here, and that would be consistent with the current state of Kansas law. The other choice is that this court could upheld the trial court and rule that one, an expert is always needed in a negligent supervision case. And I say always needed because in this case here, we have an example of a defendant who just chose not to supervise his employee. This is not an issue of like there was kind of a mixed bag and we're deciding between it. This is a very stark case where there was no supervision of its employee at all. And if there's going to be an expert needed here, then I think that would signal new law in the state of Kansas that you're always going to need an expert in a negligent supervision case. And in particular here, we're talking about an issue that does not involve technical issues, does not involve professional liability.
Counsel, you
Yes.
used 10 minutes. If you still wish to use your 5-minute rebuttal time.
No, actually, I just finished. So thank you, Your Honor.
All right, Mr. Fulston, I believe we are ready to switch over to you.
Good morning, Your Honors. I want to focus on something that the appellant's counsel just said, that this case was about conduct around students. And that is not what this case is about. Plaintiff's claim is very clearly about the administration of an entity that provides special education services to children with disabilities. It is about that administration, not about any conduct with students. That's their claim. That's the claim they decided to bring. And that administration of a special education entity is very clearly a professional judgment type of role. That is not a role that just anyone could walk in and do. That requires specialized training. That requires years of experience, training, often multiple degrees, including master's degrees and things like that. That is not something an ordinary jury would know and understand, have any basis.
I understand that the claim is brought against an entity that administers special education employees for schools. But I think what Mr. Dove was saying was that this case is not about the administration of special education services.
And that's right, Your Honor. But they did not. The court ruled they did not bring a vicarious liability claim regarding Miss Al's conduct with the minor. The court only ruled they brought a direct liability claim about specifically the administration, which includes the supervision, the hiring, and the training. All of that is, in fact, the essence of the administration, the essence of the professional job that the administrators do for.
Is it your contention that this would be considered professional services because they supervise special education teachers, or is it your contention that every school district that supervises teachers would be a professional and would require professional services and evaluation and an expert?
I don't know if necessary, and it would depend obviously on the exact facts of the case. There's obvious instances of misconduct. I think just for this very limited case where it is that specialized service that's being provided, that it does require an expert, because again, that is not something that there's specific special education training and certificates that are obtained by these administrators. Again, it's not something the jury would have any kind of frame of reference to know what exactly goes into supervising, training, hiring special education providers for children with disabilities. That is a very specialized niche, highly regulated industry.
Yes.
And so then,
if they were arguing, that your client failed to properly teach special education services, I guess I'm having a little heartburn, because it appears what they're arguing does not relate to special education services at all.
well,
Like,
the claim is
hit a kid, and I don't think you can hit a kid as a teacher, regardless of special education or not.
and I agree completely, Your Honor. But that would be a vicarious liability claim for Al's direct behavior. That's not the claim they brought. They brought a direct liability claim, which is
about supervision of a teacher to prevent her from hitting a kid.
Yes, Your Honor.
And that's specialized. The supervision required to prevent teachers from hitting kids is specialized.
I would say that the supervision overall would be specialized. And then the question becomes, what supervision should they have provided specifically for Al's? What specific supervision would have prevented this incident?
Okay,
and
so every case of liability for a school district for supervising a teacher would require an expert. Oh, Mr. Folston, are you okay? Oh gosh.
We did seem to lose Mr. Folston here.
I think Chelsea can check on him. Judge Malone, are you going to let him pause his time?
Well, of course, but
had that issue before.
that's okay. You're about 5 minutes into your argument, and I think you were in the middle of answering a question from Judge Hurst. You can just go ahead and try to continue.
Yes, Your Honor. So I apologize again. Judge Hurst, I believe I was hearing that again, I may not have heard the full question because it started cutting out. But the issue is, what should the interlocal have done differently? And how would that, and if they had done that, would that have prevented the incident? That's really the issue. So the jury needs to know, one, what should the interlocal have done? What does the standard of care require of administrators of a special education entity that provides these kind of services? And a common juror is simply not going to know what that standard of care is, because to know that, you need to know what are the industry practices, what specifically is required in this specific industry.
Well, in your case, you would put forth that the standard required was met. I mean, that's part of the argument for the case, right? The question is, do they need an expert to tell them that, or can they rely on your fact witnesses to tell them?
Well, to know if the standard of care is met, they need to have some idea what the standard of care specifically requires. Why does it require something besides what the interlocal was already doing? And if so, what? And if, because without knowing what the interlocal should have done, they certainly can't determine if that would have changed the outcome. And so, is it the industry practice for these type of entities to have the building principal provide the day-to-day supervision? How would the jury know that? And if that is the industry practice, if that is what is accepted, if that is what is done, then it wouldn't fall below the standard of care. Again, it's their burden to establish that the standard of care has been breached, and that breach resulted in the harm alleged. So the question is, if it was one, how would a jury know whether that is accepted, whether that is what reasonably prudent entities like this do? And two, what should they have done specifically so that they can determine if that would have made any difference? Facts.
Okay.
So the question then becomes, what does the jury, what evidence is there of any obvious breach? Is there any evidence of previous misconduct? Well, there's not any evidence of any previous misconduct. Is there any evidence of any, mistreating of students? No, there's not. At best, we have that she sometimes became quick to anger and sometimes her patience ran out. I frankly think that could describe almost any human being, that at sometimes their patience runs out, at sometimes they become quick to anger. What did that require the interlocal to do differently than what it was doing? The plaintiff makes a big deal out of the fact that the building principal was the one supervising, but if the school itself was providing these services, who would be the one supervising? The building principal. So if that would be what would be occurring, if that's what occurs in most cases, why is that a breach of the standard of care? Maybe there's an expert who could come in and say, well, it's best practices to do this. It's industry standard to do this. I don't know what that would be because I'm not an expert in that field. I have no experience in that field. But without that, the jury's left to speculate, oh, I guess they should have done, something, and that maybe that something would have prevented the harm. So if you look at the cases, Your Honor, the cases cited, first of all, Yunke, that involved incidents where the patient in that case had multiple previous incidents of violent behavior. There is none of that in this case. Instead, what this case more closely resembles is that of such as Gomer, which involved the selling of a hay baler without a shield. That didn't involve any type of specialized, lingo or jargon.
Well, I don't know what a hay baler is, so that does involve. I know what a teacher is, and I know what a supervisor is, but I don't know what a hay baler is. So that does involve something more specialized and technical than a teacher.
Well, I would say that I guess I don't know necessarily if I think a hay baler itself might be something a jury can learn about, but I don't know if that administering a special education entity is something that a jury can know about. That's something more specialized. But again, that just involved the sale of a baler without a shield over a protected part. And the court said that the sale of a baler without a protected part, what should be warned about, what should not be warned about, that's beyond what a jury could know, even though they have some experience in normal consumer transactions. Like they may have some experience with teachers, some experience with schools. They don't know specifically what the standard of care requires in that particular instance, what specifically the seller has to do. Just like here, what specific—
I understand your argument, Mr. Folsom. My concern is that I can't think of a time, if I follow your path, that we wouldn't need an expert.
I think there are multiple times you wouldn't need an expert. For instance, if you had previous instances of misconduct, if you had obvious incidents of, if they had came from a job where they had abused a student, if there was evidence of that, then I think a jury could say, hey, just hiring them without strict supervision would not be sufficient. If you had previous reports, previous complaints, really negative feedback.
So it's not necessarily about the technicality of the hiring entity or the supervising entity or the technicality of the services being provided. It's about whether or not they were on notice of some sort of potential problem. Then an expert would be required.
I think it's both, Your Honor. I think it's one, okay, if there's nothing obvious, is this the type of industry, is this the type of judgment that is being exercised by these administrators that a common juror would have, knowledge about what the industry standard is, what should be done, what is required? And if not, then I think the court looks to, okay, what are the facts? Are the facts so obvious that a juror doesn't really need that information? Is there previous instances of misconduct? Is there severe negative reviews? And again, we don't have any, obviously, this is not something a juror would know what the industry practices are. And two, we do not have any previous incidents. We don't have a single specific incidence of misconduct by the teacher. much less any specific misconduct towards a student. We have that, you know, she was sometimes angry and sometimes ran out of patience. Those reports notably came directly after the incident, and obviously were likely influenced pretty heavily by that incident. But again, we have a principal who's providing day-to-day service supervision. He's there every day. We have policies implemented by the entity about ESI, about not, you know, about students. And we have, if there's an issue, there's an assistant director that immediately can come and step in. And then we know there was supervision here because immediately the day this happened, the day it was reported, she was suspended, investigated, and told to either be terminated or resign. So we know there was supervision. It's not like there was just no supervision.
You have 1 minute total, Mr. Polston.
And again, Your Honor, it comes back to not the incident itself. The question is the actions of the interlocal leading up to the incident. What should they have done? What is the standard of care? What is the industry practice that they should have done that would have changed the outcome? And it's simply, there is nothing in the evidence for the jurors to know that, to know what they should have done, and much less how that would have changed the outcome. Should they have had a person in there every week with her? How would a juror know that that was the standard of care? And two, would that have changed the outcome if it was once a week? Unlikely, because that's 20% of the time. So again, there's a claim, there may be a claim for, you know, there may have been a claim for direct vicarious liability. Your employee struck this child. That could be a claim against perhaps the interlocal, that could be a claim against else. That's not the claim that was preserved. The claim that was preserved was you did not hire, train, and supervise this person in the lead up to the incident. And that claim requires expert testimony because that claim requires professional judgment, the exercise of highly specific professional judgment in the absence of any obvious negative indicators that Al's posed an undue risk. Again, the important thing is that the interlocal is not acting in hindsight, and they cannot be judged based off that hindsight. They can only be judged based off the information they had and the industry standard that they operate under. And I don't have anything further, Your Honors. If you have any more questions, I'd be happy to answer them.
Apparently there's no questions, so Mr. Dove, we'll turn to you for your rebuttal.
Your Honor, I think I've decided I'll waive my rebuttal. Thank you.
All right. Hearing no other questions, and with that waiver, that does complete this hearing, counsel. I want to thank you very much for your briefs and your arguments. This case is now deemed submitted for decision, and we will get a written opinion out to you and your clients just as soon as we can. Thank you very much. And that concludes today's hearing.
Thank you,
Thank you, Your Honors. I apologize.